Have you ever wondered what exactly separates just a bad thought from an actual full-blown crime? Today, we're going to get into the anatomy of a criminal act. We'll explore that fine legal line you have to cross to go from just thinking about a crime to actually committing one.
All right, here's our game plan. We'll start with the basics of what makes something a crime in the first place. Then, we'll break down the 4 essential ingredients that every crime needs. After that, we'll track the journey from a simple thought to a completed action, and then, this is the fun part, we'll dive into a real-life case to see how the courts handle all this. And finally, we'll wrap it all up with the key takeaways.
So, first things first, what actually makes an act a crime? It's not as simple as just doing something bad. There's a very specific legal framework that has to be satisfied.
And that brings us to a really fundamental question, maybe the most important one of all. Can you get in trouble just for thinking about committing a crime? The answer here is the key to understanding, well, everything else we're about to talk about.
And the answer is a pretty firm no. A crime isn't just a thought. Legally speaking, a crime is one of 2 things. Either you do something the law specifically forbids, or, and this is just as important, you fail to do something the law says you must do. Either way, it's considered a wrong against society itself.
So, what are the actual building blocks here? For any action to be legally considered a crime, prosecutors have to prove that 4 essential elements are present. Think of it like a recipe. You need all the ingredients. First, the act has to be done by a human being. Simple enough. Second and third, these are the 2 big ones, and they've got these cool Latin names. Mens rea, which is the guilty mind, and actus reus, the guilty act. And finally, there almost always has to be some form of injury or harm.
Okay, let's zoom in on mens rea and actus reus, because this is really the heart of criminal law. They are the 2 absolute key ingredients. Mens rea is the mental part. It's the intention, the knowledge that you're doing something wrong. And actus reus is the physical part. It's the actual action, or lack of action, that brings that guilty thought into the real world. You almost always need both working together. In fact, this idea is so fundamental that it's summed up in this ancient legal maxim that forms the bedrock of modern criminal law. Actus non facit reum, nisi mens sit rea. It basically means an act doesn't make a person guilty unless their mind is also guilty. The action and the intention have to be linked.
So, if a crime needs both a thought and an action, how does it all come together? Well, let's trace the typical path a crime takes from that first little idea all the way to the final act.
Most crimes unfold in these 4 stages. It all starts with intention. That's just the idea in your head. Then comes preparation, where you start getting things ready. Stage 3 is the critical one, is the attempt. And finally, you have the commission, when the crime is actually completed. Now, here's the kicker. The law usually only gets involved at stage 3.
So why aren't those first 2 stages usually punished? Well, the law generally sees them as being just too far removed from any real harm. Plus, think about it. It's incredibly difficult to prove that a thought or some early planning would have definitely led to a crime. People change their minds all the time, right?
But, and this is a huge but, there are some major exceptions. For really serious crimes, the law's not going to wait around. Things like preparing to wage war against the government, getting ready to make counterfeit money, or planning a massive armed robbery. In these cases, the preparation itself is considered so dangerous that it becomes illegal.
This all brings us to a really tricky question. Where exactly is that line between harmless preparation and a criminal attempt? To really get a feel for this, there's nothing better than looking at a real case and seeing how the judges wrestled with it.
And the perfect example for this is a classic case from 1961, Abhayanand Mishra versus the state of Bihar. If you've ever studied criminal law, you've definitely heard of this one.
Okay, so here's the story. Mr. Mishra wanted to sit for a master's exam, but he didn't actually have the right qualifications. So, what does he do? He forges his documents and sends them off to the university. The university buys it, at least at first, and they send him back an admit card. But just before the exam, someone discovers the whole thing is a fake. And right there, that's the legal puzzle. Mishra's argument was, hey, I was only preparing to cheat. I never actually walked into the exam room. I never wrote a single answer. So had he actually crossed that line from preparation into a criminal attempt to commit fraud? What do you think?
Well, the Supreme Court didn't buy his argument for a second. They ruled that his actions went way beyond simple preparation. The court decided that the very moment he put those false documents into the university's hands, he had officially made a criminal attempt. And the court's reasoning here is so important. They explained that an attempt isn't just the very last thing you do before succeeding. No. It's any significant action you take after you're done preparing that moves you directly toward committing the crime. For Mishra, mailing those forms was that action. He'd done everything in his power to set the fraud in motion.
Okay, so after all that, let's sum things up. What are the key takeaways from our little tour through the anatomy of a crime?
First, always remember those two magic ingredients. You need the guilty mind, mens rea, and the guilty act, actus reus. Second, criminal liability. It almost always kicks in at the attempt stage, not before. Third, that blurry line between preparation and attempt, it's crossed the moment you take a direct step toward the finish line, just like Mishra did. And finally, it all comes down to the specific facts. Every case is its own unique puzzle.
And that leaves us with a final, kind of mind-bending question to think about. Our whole legal system is built on the idea that we can't punish thoughts because, well, we can't truly know them. But what if that changes? What if someday technology could prove criminal intent with 100% certainty? Should the law change with it? Should a thought alone ever be a crime? It's a really fascinating ethical puzzle to chew on. Thanks so much for joining me.